Here is a summary of the second opinion of June 5th, 2025, BLOM Bank SAL versus Honickman, case number 23-1259. I'll walk through the opinion, give my thoughts on case implications, and also analyze Justice Jackson's persistent oral argument questions and how they roadmapped her partial concurrence. Please note that this summary is read by an automated voice. The question presented in this case is whether Rule 60b-6's stringent standard applies to a post-judgment request to vacate for the purpose of filing an amended complaint. Justice Thomas delivered the opinion of the court, in which Chief Justice Roberts and Justices Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Barrett joined, and in which Justice Jackson joined in all parts but Part 3. Justice Jackson filed an opinion concurring in part and concurring in the judgment.
Justice Thomas's majority opinion: plaintiffs, who are victims and families of victims of terrorist attacks carried out by Hamas between 2001 and 2003, sued BLOM Bank SAL under the Anti-Terrorism Act for allegedly aiding and abetting the attacks by providing financial services to Hamas-affiliated customers. BLOM argued that the complaint failed to state a claim, and plaintiffs repeatedly affirmed they would not seek to amend their complaint if it were dismissed. The district court dismissed the complaint with prejudice, finding that plaintiffs had not adequately alleged that BLOM had the requisite general awareness for aiding and abetting liability. The court denied leave to amend because plaintiffs had declined several opportunities to amend and failed to identify additional facts they could allege. The Second Circuit affirmed the dismissal, finding that even though the district court had applied too stringent a standard for the general awareness element, plaintiffs' claims still failed under the correct standard. Following the affirmance, plaintiffs returned to the district court and moved under Federal Rule of Civil Procedure 60b-6 to vacate the final judgment so that they could file an amended complaint to meet the Second Circuit's clarified standard. The district court denied the motion, ruling that the Second Circuit's clarification did not constitute the extraordinary circumstances required for Rule 60b-6 relief, and that plaintiffs' prior deliberate choices not to amend counseled against relief. On appeal, the Second Circuit reversed, holding that when a party seeks Rule 60b relief to file an amended complaint, district courts must not apply Rule 60b-6's extraordinary circumstances standard in isolation, but must instead balance Rule 60b's finality principles with Rule 15a's liberal amendment policy. Held, relief under Rule 60b-6 requires extraordinary circumstances, and this standard does not become less demanding when the movant seeks to reopen a case to amend a complaint. A party must first satisfy Rule 60b before Rule 15a's liberal amendment standard can apply. A Rule 60b-6 is a catch-all provision that provides relief from final judgment for any other reason that justifies relief beyond the specific grounds in Rule 60b 1 through 5. The text and structure of Rule 60b make clear that this catch-all provision is available only in narrow circumstances. It covers grounds not already covered by the preceding 5 paragraphs, and a broad interpretation would improperly circumvent the time limitations of those paragraphs. The court has consistently held that relief under Rule 60b-6 requires extraordinary circumstances, as first established in Claprott v. United States and reaffirmed in numerous subsequent decisions. This strict interpretation is essential to preserve the finality of judgments. B. The Rule 60b-6 standard does not change when a party seeks to reopen a case to amend a complaint. In that circumstance, satisfaction of Rule 60b-6 necessarily precedes any application of Rule 15a. Rules 60b and 15a apply at different stages of litigation and require separate inquiries. Rule 15 attues direction that courts should freely give leave when justice so requires, governs pretrial amendments, but does not apply when a case is closed following final judgment. A party seeking Rule 60b-6 relief must demonstrate extraordinary circumstances regardless of what they intend to do if the case is reopened. The Second Circuit's balancing approach is not consonant with Rule 60b-6 and this court's precedents because it improperly dilutes Rule 60b-6's stringent standard. C. Plaintiffs' arguments that the Second Circuit's approach is consonant both with Rule 60b-6 and with this court's precedents are unpersuasive. Balancing the strict standards of Rule 60b-6 against the more relaxed standards of Rule 15 necessarily weakens the former and is thus incompatible with this court's long line of precedents holding that Rule 60b-6 should only be applied in extraordinary circumstances. Foman v. Davis does not suggest otherwise. Foman dealt with Rule 59e, which does not threaten the finality of judgments to the same degree that Rule 60b-6 does. Thus, a Rule 59e movant is not required to show the same extraordinary circumstances to receive relief. D. The Second Circuit's disposition of this case was incorrect. District Court's Rule 60b rulings are reviewed only for abuse of discretion. The District Court's determination that plaintiffs failed to demonstrate any extraordinary circumstances warranting relief under Rule 60b-6 both applied the correct legal standard and provided substantial justification for its conclusion. The District Court's justifications for its decision align with established Rule 60b doctrine that intervening legal developments rarely constitute extraordinary circumstances and that extraordinary circumstances must suggest the movant is faultless in the delay. Reversed and remanded.
Justice Jackson's opinion, concurring in part and concurring in the judgment. I join all but part 3 of the court's opinion. I agree with the court's conclusion that when a district court considers a movant's desire to amend his complaint in the context of a motion to reopen a case under Federal Rule of Civil Procedure 60b-6, the Rule 60b-6 standard, rather than the Rule 15 standard, applies. Given the deference owed to lower courts with respect to Rule 60b-6 determinations, I also agree that the district court did not abuse its discretion in denying reopening here. I write separately to emphasize that our affirmance of the district court's denial of reopening in this case does not require accepting all aspects of the district court's reasoning. In particular, I think the district court was wrong to fault plaintiffs for making a deliberate choice to appeal the dismissal of their complaint in lieu of accepting various pre-dismissal opportunities to cure purported pleading deficiencies. The district court based that aspect of its reopening determination on our opinion in Ackermann versus United States. But, as I explained below, the choice that plaintiffs made, declining to amend, does not categorically preclude Rule 60b-6 relief under that precedent. Rule 60b permits district courts to reopen cases after the entry of a final judgment under a limited set of circumstances, including fraud, mistake, and newly discovered evidence. This rule attempts to strike a proper balance between the conflicting principles that litigation must be brought to an end and that justice should be done. The 6th paragraph of Rule 60b is the provision at issue here. It is a catch-all that permits reopening for reasons not covered in the rule's preceding 5 paragraphs. The opening paragraphs of subsection B specifically enumerate various bases for relief: mistake, newly discovered evidence, fraud, and the voiding or satisfaction of a judgment. Then, under paragraph 6, a court may, on motion in just terms, reopen a judgment, order, or proceeding for any other reason that justifies relief. Rule 60b-6, provided that the motion is filed within a reasonable time. Rule 60c-1. Because of the mutually exclusive nature of Rule 60b's provisions, Pioneer Investment Services Company v. Brunswick Assocs LP, this court has long held that relief under Rule 60b-6 is available only in narrow circumstances. We have thus required Rule 60b-6 movants to demonstrate that extraordinary circumstances justify reopening the case. In this court's first case applying Rule 60b-6, we concluded that reopening was warranted where a movant alleged an extraordinary situation, namely, that he had been stripped of his citizenship by default judgment while he was, among other things, incarcerated and in ill health. The court considered a similar Rule 60b-6 request for reopening in the context of a denaturalization proceeding 1 year later in Ackermann and reached a different outcome. We upheld the denial of the Rule 60b-6 motion, expressly distinguishing Klaproth. Critically, the movant in Ackermann had sought reopening only after making a considered choice not to appeal the adverse judgment, id. at 198. Given the need for an end to litigation someday, we explained that a movant cannot be relieved of such a choice because hindsight seems to indicate to him that his decision not to appeal was probably wrong. Under this line of precedent, the court has concluded that due diligence by the movant is a prerequisite to obtaining Rule 60b-6 relief. For that reason, we have consistently found reopening inappropriate where, as in Ackermann, a movant deliberately terminated the underlying litigation. Relying on Ackermann, the district court below suggested that plaintiffs could not demonstrate extraordinary circumstances because they had made a documented series of deliberate choices not to cure the deficiencies identified in their pleading. The district court thus faulted plaintiffs for believing that their complaint alleged sufficient facts and declining to amend it. They opted instead to seek clarification from the appeals court regarding the sufficiency of their pleading. In my view, the district court should not have assumed that Ackermann's lack of due diligence principle applies under these circumstances. Plaintiffs did not abandon this litigation. Instead, they diligently pursued their statutory right to appeal on the grounds that, in their view, the district court had mistakenly concluded their complaint was insufficient. To be sure, the courts below did ultimately find that the factual allegations in plaintiffs' complaint were deficient. But that just means that plaintiffs were overconfident about the strength of their pleading and their prospect of success on appeal. A misstep of this nature is not abandonment, far from it. And the fact that a plaintiff opts to appeal does not alone preclude Rule 60b-6 relief, provided that he can otherwise demonstrate extraordinary circumstances and has not exhibited neglect or lack of due diligence. The bottom line, jurisprudentially, is that courts should refrain from reflexively denying reopening for amendment purposes when a Rule 60b-6 movant's only purported fault was a prior decision not to amend the complaint. A plaintiff may have good reasons for seeking clarification from the appeals court before taking the significant step of amending his pleading. In this case, for example, plaintiffs allege that BLOM Bank SAL aided and abetted Hamas's commission of certain terrorist attacks by providing financial services to customers who were allegedly affiliated with Hamas and who had helped further Hamas's goals. These are serious allegations. One would reasonably expect plaintiffs to exercise great caution before making additional factual assertions that further link BLOM to alleged terrorist activities. Moreover, and importantly, denying reopening after appeal merely because the plaintiff previously declined to amend the complaint risks undermining the statutory right to take an appeal from any final decision of a district court. If a plaintiff is necessarily at fault for Rule 60b-6 purposes, just because he exercised his right to appeal, then plaintiffs will be disincentivized to go to the courts of appeals even when they reasonably believe the allegations in their pleadings are sufficient. That outcome not only divests them of their right to appellate review, but could also leave important legal questions regarding pleading sufficiency unanswered. It is particularly inappropriate to deny Rule 60b-6 reopening based on a prior refusal to amend, where a clear intervening change in the law supplies the necessary extraordinary circumstances. To treat the plaintiff's prior refusals to amend as dispositive in such a situation would be manifestly inconsistent with the preference expressed in the federal rules of civil procedure in general for resolving disputes on their merits. This court reviews the denial of a Rule 60b motion only for an abuse of discretion and does not opine here in the first instance as to whether these plaintiffs have demonstrated extraordinary circumstances. The district court's primary justification for denying plaintiffs' motion to reopen was that the Second Circuit's clarification of the applicable legal standard did not qualify as an extraordinary circumstance, particularly when plaintiffs were unlikely to prevail even under the clarified standard. I concur in today's judgment because I agree that the district court did not abuse its discretion with respect to denying Rule 60b-6 relief on that basis. But I find the district court's alternative ground for denying reopening, that plaintiffs were at fault because they declined prior opportunities to amend their complaint, neither persuasive nor consistent with core tenets of Rule 60b doctrine. Assuming extraordinary circumstances otherwise exist, a plaintiff should not be faulted under Rule 60b-6 for reasonably having chosen to appeal rather than amend his complaint.
Case implications. Next, let's compare the opinion to oral arguments. Here, I want to focus on Justice Jackson's questioning and her subsequent partial concurrence. When re-listening to oral argument, Justice Jackson's persistent questioning stood out. While most justices ask a few questions and move on, Justice Jackson engaged in extended colloquy with the attorneys. Justice Jackson zeroed in on a specific concern. Should plaintiffs lose the right to amend a complaint just because those plaintiffs chose to appeal a dismissal rather than immediately amend? Here's how this played out. Early in the argument, Justice Jackson expressed worry about parties being
punished for exercising the right to appeal.
When the bank's lawyer tried to sidestep the issue, Justice Jackson constructed a detailed hypothetical scenario to illustrate the problem.
I'm worried about this.
Justice Jackson said,
If the district court gives them leave to amend or says, hey, you can amend before I dismiss your complaint, the plaintiff could follow that recommendation. Or the plaintiff can choose to appeal and say, no, I actually think my complaint is sufficient.
Justice Jackson pressed the point further.
It's okay to amend if you don't appeal, but if you appeal and lose, you're not going to be able to amend anymore.
Even after the conversation moved to other topics, Justice Jackson circled back with another hypothetical about a plaintiff who
files a complaint that he thinks is sufficient,
declines to amend when given the opportunity, appeals, and then loses that appeal. This tenacious questioning stood apart from the more scattered approach of other justices. Justice Jackson was drilling down on a principle. The right to appeal shouldn't cost plaintiffs the chance to later amend if that appeal fails. In her concurrence, Justice Jackson agreed with the core holding about which legal standard applies, but then directly challenged the idea that choosing to appeal should count against plaintiffs under Rule 60b-6. I think the district court was wrong to fault plaintiffs for making a deliberate choice to appeal the dismissal of their complaint instead of accepting opportunities to cure purported pleading deficiencies, Justice Jackson wrote. The language mirrors those oral argument questions almost perfectly. Where Justice Jackson worried about characterizing
the choice to appeal as a tactical waiver of the ability to amend,
during oral arguments, the concurrence argues that courts
should not assume that the lack of due diligence principle applies
when a plaintiff chooses to appeal rather than amend. Justice Jackson's written opinion expanded on the courtroom concerns about
burdening the right to appeal,
warning that denying plaintiffs the chance to amend after appeal
risks undermining the statutory right to take an appeal,
and could
disincentivize plaintiffs from going to appeals courts even when those plaintiffs reasonably believe the allegations are sufficient.
What makes this fascinating is watching how Justice Jackson used oral argument to identify a problem, and then the concurrence to develop a more sophisticated legal solution. In the concurrence, Justice Jackson distinguishes between different types of fault under Rule 60b-6. For legal context, Rule 60b-6 allows reopening a case after final judgment only in extraordinary circumstances, and courts often look at whether the party seeking reopening is at fault for the situation. Justice Jackson argues that choosing to appeal rather than amend isn't the kind of fault that should prevent reopening a case. This is especially true in cases like this one involving terrorism allegations, where
plaintiffs would reasonably exercise great caution before making additional factual assertions linking a bank to alleged terrorist activities.
The concurrence also offers guidance on when previous decisions not to amend shouldn't be held against plaintiffs, particularly
where a clear intervening change in the law supplies the necessary extraordinary circumstances.
the contrast between Justice Jackson's approach and the majority opinion is striking. While the main opinion endorses the district court's reasoning about plaintiffs' deliberate choices not to cure the deficiencies, Justice Jackson's concurrence explicitly rejects this as neither persuasive nor consistent with core tenets of Rule 60B doctrine. This could have real impact in future cases. Justice Jackson articulated a principle that could guide lower courts. A plaintiff's decision to appeal rather than amend shouldn't, by itself, prevent reopening a case later. This could be particularly important when there's genuine dispute about the legal standard, when the law changes during appeal, or when plaintiffs have legitimate reasons to be cautious about amending without guidance. What we're seeing here is a masterclass in judicial technique, identifying a specific issue through focused questioning, and then using a concurrence to develop a nuanced legal principle that might influence future cases, even without becoming a binding majority rule. The Jackson approach would protect the right to appeal without forcing plaintiffs into a false choice. Either amend now based on potentially incorrect legal standards or lose the chance to amend forever. This balances the competing values of finality in litigation with the fundamental right to appeal incorrect legal rulings, exactly the kind of careful balancing act that makes Supreme Court jurisprudence so fascinating.